All right, everybody. Welcome to Mobile Monday. It's 12:58, so we're going to hang out for a few minutes, and while people are logging on, we can cover a couple of housekeeping items. My name is John Waite, and I am here to give you guys the forms changes on behalf of NC Realtors today. There's already a video uploaded on this on the YouTube page for NC Realtors. So there, if you want to, like, let's say, for example, you just like pressed on something right now and you can't really do this Mobile Monday, but you really need to know the forms, you don't know what to do. Guess what? This is already recorded. It's already on the YouTube page. You can go do that at your leisure if you wish. But if you wish to stick around and hear this presentation, you certainly can. There will be a Q&A at the end. Um, Leah's going to put questions in the chat kind of as we go, and I'm going to look at it at the end. So at the end is when we will cover any questions that you guys may have. I'm going to start today. I'm going to go ahead and share my screen here and just let you know probably the most important resource as far as forms changes go. Here, this is ncrealtors.org. I'm not even logged in. Like, you don't even have to be logged in to see this stuff. It makes it super simple. So what you can do is you can go here, you can go to legal Q&As, and then these legal Q&As are the same Q&As that come in the Realtor Rundown every Monday. So if you want to go look at the Q&As, and actually this is like a secret, a lot of times the Q&As are actually put out on the website on Friday. So if you're a BIC who needs to have a topic, for early Monday morning meeting or something like that, a lot of times the Q&A will already be on the website on Friday, and then that way you can go ahead and be prepped for your Monday meeting if you have one with your team. Here in the Q&As, though, you can see here is the summary of forms changes. Here's residential, property management, and commercial. I'm pretty sure this week the videos will be uploaded for commercial and property management. I have not done those yet, but I expect by the end of this week those will be available for you as well if you need to look at those forms changes. Over here, you can see on this window on the left side, summary of forms changes is right here as well. And this is previous years. So if you want to look at previous years of forms changes, you can see the summaries here. I think they go back to what, 21? Yeah. We do on the NC Realtors Legal Hotline, we have access to forms changes that are older. I don't know why you would need that, but every once in a while you guys do. So every once in a while there's like an old form floating around, like an old referral agreement or something like that. You may have a question on an old form. We do have access to things like that and can help you if you have if you have questions anytime. You can access the NC Realtors Legal Hotline as a free member benefit. You can email or call. Either one is fine, although I would request that, if you really want to respond to writing, start with the email first. That just makes it easier, because if you call and leave a message, we are going to call you back. And that means that if you send a call and an email, then you might get two responses, or, in some cases, people will, talk to me on the hotline for 20 minutes and then want a follow-up email about the conversation. And no, it's very the call volume is such that accommodating that is very difficult. So if you want a response in writing, start with the email first, and then that way you can get a response in writing for your records if you need it. But in any event, that is the best place to go. Like, if you want to follow along today, if you go to the summary of forms changes for this cycle, which is just in the regular page here. So what it is, I went over legal and ethics, go down to legal Q&As. Down here is the Q&As, and you scroll down just a little bit because they're in sorted by date automatically. You can click on residential forms changes right here, and that will take you to all the forms changes. And you can see here, you click on these, it will take you to the hyperlinks that we are about to go to right now. So if you want to follow along that way, you definitely can. I'm actually going to start with Form 220, so let's go ahead and just dive right into it. This is the newly revised Form 220. You don't see any yellow on here because it's been completely redrafted. It is totally different than previous version of Form 220. Just as a side note, 60 days from July 1st, which is when the new forms came out, you can use the old forms. Some of the vendors will have both versions of the forms in there, and the old versions of the forms should also be on ncrealtors.org, I think. If not, if you need a version of an old form for the next 60 days, if for some reason you can't find it, let us know. We can email you a copy on the hotline or guide you to try and find it. Like I said, some vendors will have both versions. They'll have old forms and new forms in the library, and that's the grace period. After 60 days, you will see the old forms disappear, and then everyone needs to be moved over to the new forms. So as to 220, you can see here that the option for the listing firm to offer compensation has been eliminated. And with that, North Carolina will join a majority of states who have already made this change. Uh, I've talked about this many times, so I'm not going to belabor the point today because I want to try to keep this within an hour for you guys. But I am encouraging people to make the change away from the listing firm paying compensation to the buyer agent firm. It is simply a landmine. Is it a landmine that is guaranteed to explode? No, no. But there has been scrutiny of that practice in the past with residential transactions. Now, granted, it wasn't the exact reason the settlement happened. In Missouri, it wasn't the specific thing that was addressed in that. In fact, following the settlement, you probably heard people from NAR talking about how the buyer agent compensation being shared by the listing firm was not a practice that was eliminated by the settlement. However, since the settlement happened 2 years ago, over 2 years ago now, it has been something that everything is being examined from a risk management standpoint. And this is something that a lot of states have looked at. And some states have even gone so far as to actually outlaw the practice in residential transactions of firm to firm compensation. Now, notice I'm saying residential. Commercial is still the same. And the forms in North Carolina are still the same. So if you are using commercial forms and you're doing a listing agreement, then your compensation as a listing firm is something that you can share with a buyer agent or a seller subagent, as the case may be. That is still something where the forms are the same and the process is the same. On the residential side, however, with new Form 220, the focus will be on the seller offering buyer agent compensation if they wish. And notice that this is actually a designed addendum. Now, with the way the forms changes were approved this year, it was not possible to put Form 220 as an actual box in the addenda options in the offer to purchase and contract, but I would expect that will be addressed by the Forms Committee and by the Joint Forms Task Force early on this cycle. So hopefully that'll be something that would be able to be accommodated. But as for right now, just understand that this addendum is something you put on the other attorney drafted addenda line, identify it there. And notice the first line here says, in addition to any other concessions. What that is referring to is the seller concessions there on the first page of the offer to purchase a contract. We'll look at that in just a second. But whatever is in this addendum for buyer agent compensation will be in addition to that. And I've gotten the question several times now whether this counts against the interested party cap for Fannie Mae and Freddie Mac. And the answer to that is no. And that's been true for quite some time. In fact, very soon after the settlement was adopted, Fannie and Freddie both clarified the rules to make it clear that seller concessions, if part of those seller concessions were for buyer agent compensation, then they would not count against the interested party cap for seller concessions in the contract. And so that's been true for quite a while now. And that's why a lot of these states have been able to already make this transition. And if you in South Carolina in the offer to purchase a contract, I think the way that they do it, or at least the last version I saw, it may have changed. Somebody can correct me if I'm wrong. But there's a total amount of seller concessions, and then you identify how much of those seller concessions are actually for the seller to pay the buyer agent and go toward the buyer agent fees. So that is new Form 220. You can see it's got a lot of things that are not in the other form, like there's not an end date anymore in paragraph 3. There is no paragraph 3. There's no option for listing firm. If your firm still wants to do firm to firm sharing of compensation in the residential context, you can do that. It's not illegal in North Carolina, but you will need your own forms to do it. And so this form is simple enough, but let's look at the listing agreement and the changes to the listing agreement that go with the redrafted Form 220. So you can see here in paragraph 7, First of all, you've got to change here in the checkbox. Now you've got an option for an unrepresented buyer and to negotiate with the seller what your compensation will be in that context, because unrepresented buyers can be off the chain, man. So you can negotiate that with their seller and talk to them about some of the issues that come along with that context. You can see here's the old language in the offer to purchase contract. Okay. Here's the new version, new part here. And you can see that it is down to two checkboxes instead of three. And this is where the seller can authorize the listing firm to go out and advertise how much compensation they may offer to a buyer agent if the rest of the contract terms are appropriate and acceptable to the seller. So that's where this is where the listing firm gets its authorization to talk to buyer agents about that. Now, I know a lot of you in the past, you would take Form 220 to your listing appointment, have that filled out, and then use that as kind of your authorization. Now, can you still do that? Yes, you can if you wish. But otherwise, you can see because this is actually an addendum to the offer to purchase, then really it's designed to be part of the offer process, offer and acceptance process. So can you fill this out ahead of time? Yes. Or just bring a sample with you to the listing appointment. Sure. All those things. But this part here that I've highlighted, the first checkbox is where the seller actually authorizes you as a listing firm to go out and talk about buyer agent compensation in the broader marketplace. Okay. And then you can see here, there's a second checkbox where if you're still going to use firm to firm compensation, then you can attach your own policy. You will need your own form to sign with a buyer agent, but that is something that you can do if you choose to. Um, Again, I will stress it is something that is a risk management issue that if your firm wants to do that, talk to your counsel and figure out the pros and cons of whether to go with what is proposed in the new Form 220 or whether you want to do your own version as far as agent compensation goes. But that'll be up to you and your attorney to talk about. All right, we're going to come back to the listing agreement in just a minute, but I want to move on to the offer to purchase a contract and the changes that are in there. So here you can see the first thing is that now you can see for additional parcels, we're going to cover this in just a second. There's a new Form 2A10-T that you can attach to the contract and do additional parcels if you wish. Down here, you can see the due diligence fee is still due on the effective date, okay? And there's some changes here, but it's really just formatting. You can see down here the capitalizations are removed and things like that. Down here, though, is really where the big change is because now there's language that states that even though the due diligence fee is due on the effective date, it has to be delivered no later than the next banking day following the effective date. So what that's going to do is going to give you a little extra time where now if your client goes under contract late on a Friday, then they are now going to have till Monday, the end of Monday, to pay the due diligence fee to the seller and not have it be late. So it's not like they're going to go into contract and then, on Saturday when maybe their bank is not open or most buyers, for whatever reason, go under contract when they're on vacation. I don't know why that is, but it's a very frequent hotline call. In any event, the buyer now has some built-in time, built-in grace period to make that payment and not be late. So let's say your client goes under contract. Well, in banking day, this little term here is defined later in the contract, and we're going to look at that in a minute. But banking day is essentially going to be any Monday through Friday, excluding Saturday and Sunday, and certain holidays by the Federal Reserve. So banking day is defined in the contract. So let's say your client goes into contract on a Friday, late on a Friday, and then Monday is not a holiday. So, let's say the buyer does not pay on Monday. Then Tuesday, the seller would be able to send a demand saying, hey, you didn't pay the money on time. You now have one banking day from the notice today to pay. Then the buyer would have Wednesday. Then that means the seller would have the ability to terminate on Thursday. Okay. So why do I bring all that up? I know a lot of times, you guys will have some grace when you're in the listing agent chair for buyer agents who may be dealing with something like this because, buyer agents you guys are just doing the Lord's work out there, trying to get buyers to the closing table and to get them to do the things they need to do to actually complete the transaction. Okay. And I think listing agents who have been in that position before understand that, sometimes a little bit of grace is necessary in order to let the buyers be able to, pay the money that has been agreed to in the contract, delivering the earnest money, delivering the due diligence fee and things like that. You guys deal with this every single day, right? Just understand now, though, with this change in the contract, to the extent that you've had some leniency in the past when you're in the listing agent seat, then it's just something where, how much leniency are you actually going to give when there's that much, grace built in? Now, there's not as much grace if you change the facts just a little bit. Like you go under contract on Monday, it's not a holiday. The buyer does not pay on Monday. Then that means that they would have the next banking day following the effective date to pay. So that would be Tuesday, right? Then let's say the buyer doesn't pay on Tuesday. That means the seller could make a demand on Wednesday. The buyer would have Thursday. And if the buyer doesn't pay on Thursday, then the seller could terminate on Friday, you know? So that's a very different, process. And before in that same scenario, like if you have a contract that's on the current contract, like let's say you're not using the new version of this form, then you would have made, if you went under contract on a Monday, it was due on Monday. If they didn't pay on Monday, the seller can make a demand on Tuesday. And if the seller made a demand on Tuesday, and then the buyer would have Wednesday, then they could terminate Thursday. So in that scenario, you see those two different scenarios. It's really a difference of one day, right? So it's not that much in some scenarios. In my first scenario, where you're talking about a buyer going on contract on a Friday, then yeah, okay, it's more time, but it's not a lot more time. In any event, just make sure that you're being, cognizant of that as a listing agent, and work with buyers, and buyer agents as you ordinarily would. Get a feel for the transaction, get a feel for your gut, get a feeling of, where are we at and how much leniency is appropriate for a particular buyer, and then feel free to go from there. But just understand that as far as when the due diligence fee, as far as the due diligence fee is still due on the effective date, but it can be delivered no later than the next banking day before it becomes late. Okay, so that's how that new mechanism works. All right, going back up a little bit here. There's no other real big changes in here that I think we need to cover, but I will note, you can notice that seller concessions have not changed. So here, in addition to buyer agent compensation, if any, seller shall pay at settlement, et cetera, et cetera. Okay. So that makes an accommodation for the new Form 220. And that's, those two things, when you're negotiating them, understand they're two different things and they will be in addition to each other. So make sure you negotiate that. And when you do the contract, that the funds are credited appropriately according to what the seller and the buyer agreed to. All right, moving down here, those two other paragraphs have been moved. You can see here they've been moved up. Home warranty, though, will be on the second page. So just make a note of that. It used to be much later in the contract, but now it's going to be on the second page. Moving down in the offer to purchase, here you have a redundancy that's being deleted here. This language here under loans and other funds is not being deleted because it's not, applicable anymore. It's still applicable. Like changes to this are still going to be material. It's just that the language is up here and A applies to this whole section. So there's no real change there. Make sure you're disclosing that if you got a client that's making a change. Here you got some subheadings. Those are not big changes there. Here you've got a change in, concerning FinCEN and the reporting rule. That reporting rule is currently suspended by court. It could pop up at any time. I don't know when that will be. If it still hasn't popped up by the end of next cycle, then maybe there's a paragraph that may be adjusted so that it doesn't reference FinCEN specifically. But if FinCEN does kick in at any point during the next year, it makes sense that this would stay in there. Plus, you can see this language is applicable to a lot more than FinCEN. The buyer must provide the closing attorney with any information necessary to comply with governmental reporting requirements, including but not limited to the FinCEN rule. So that language is meant to be more broad, just because, even if FinCEN goes away, this is an obligation that the buyer should have to give the closing attorney to be able to complete the transaction. You got some technical edits to the lead-based paint paragraph, and make sure you're giving the brochure and the lead-based paint addendum when appropriate. Here, you've got a change to the access to property paragraph. And this change is small, but pretty big. And what it says is that until the due diligence fee is delivered, physical access, not all due diligence, just physical access to the property may be limited or denied by the seller. Does it have to be? No. Can it be? Yes. Was this also true in previous versions of the form? I think so. I mean, that's just me personally. If you got a contract pending on the current contract that doesn't have this language, you can see here in the first sentence it says seller shall provide reasonable access to the property. Let's say a buyer goes into contract on Monday, and they have not paid their due diligence fee, and they show up. Let's say you go into contract early and a Monday buyer shows up, you know, at lunch on Monday, or maybe shows up on Tuesday, right? And technically on Tuesday, the due diligence fee, would be late at that point under the existing old, let's say the old version of the form, the one that was applicable in 2025. But if that's the case, the buyer's not late yet, right? The seller can make a demand for the money, but the buyer is not in a breach yet to a point where the seller has a right to terminate. Well, so let's say the buyer shows up on Tuesday wanting to get into the home. They've got their contractor or whatever, and they want to walk through the home. Okay. Well, it says the seller shall provide reasonable access. Is it reasonable in that scenario that I just described for a seller to deny access and be like, hey, no, I mean, you're supposed to pay the due diligence fee for the right to conduct due diligence. You haven't paid it yet. You can't get in the property. Is that reasonable for the seller to say that? I think most people would probably say yes. And so to me, if you've got a contract on the old contract, and this is a common hotline call where the parties are fighting about what is reasonable access or not, and ultimately, if the parties can't agree, then it'd be up to a court to decide anyway. But if you're just asking my personal opinion, I think there's an argument to be made under old versions of the form as well that reasonable access would mean no, you're not going to go into contract, show up with a contractor, the same day or the next day, demanding to get in, and then try to get in there, get a look, and then maybe terminate without paying the due diligence fee, and then leave the seller with a decision of, do I sue the buyer to get the due diligence fee that they said that they were going to give me? So, and the reason this change was made is because that practice was actually happening. It's not like that's, what I just described there is not hypothetical. It's something that was happening pretty regularly and putting the sellers in a difficult position. So, that is as far as where that comes from and what it means. It's just making it clear that the buyer can do other kinds of due diligence and they want to investigate other parts of the property, fine. But as far as getting into the property, physical access, that's something that the seller would be able to say, no, 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 no. Like you need to pay the due diligence fee before I'm going to give you access to the property. All right, moving on down. You've got an edit here, and it's basically, these Romanettes in paragraph 8I were put in there so that you should hardly ever be filling out this blank. If you're still filling out this blank, just know it is pretty likely your closing attorney is ignoring whatever you put in there. These Romanettes were suggested by attorneys on the Joint Forms Task Force to help make it easier for them to figure out how to make the deed. A lot of closing attorneys do their own investigation anyway. But every once in a while, you'll have a closing attorney asking for an assignment. An assignment's not always necessary if you're going to have a deed filled out this way. However, that said, if a closing attorney still asks for an assignment, there might be a reason for that. It might be because they want some paperwork to cover themselves. If, for example, one of the buyers says, hey, don't worry, we're just going to put the deed in this name over here. And especially if there's other buyers in the transaction, a closing attorney may want some paperwork to show that the other buyers agree to that. So the language has been added here to make it clear. These Romanettes, this is not an assignment. This is about a transaction and who the deed is to be made out to. It's not an assignment situation, but understand that if a closing attorney still asks for it, there may be other reasons for that. So, that's where that language is coming from. Moving on down here, you got another the banking day edit, and that's here. This paragraph, a lot of times I'll get calls on the hotline, And it's basically how do you count days and time? Well, the paragraph is right here in paragraph 22. So banking day has been added to that to try and make it a little bit more clear how we're counting days and time. All right. Those are the big edits to the offer to purchase and contract. Let's go ahead and move on to the new construction addendum, which got some heavy revisions this year. In the past, it was a pretty common hotline call where agents would have a house that's mid-construction. And so the question was, do we use the offer to purchase a contract with the new construction addendum, or do we use Form 800T, the new construction contract? Like how do we do that? How do we navigate that? How do we decide which contract is most appropriate? And the answer in the past was depends. And it would depend case to case, and that's still somewhat true. However, with the revisions to the new construction addendum, you can see now there's a specific moment in time when to use this form. If the drywall in the dwelling is complete, then probably, most likely, the new construction addendum with the offer to purchase is going to be more appropriate than new construction. Okay. Now, there's going to be all sorts of gray in there where that could shift and be different in different transactions. But, and ultimately, it's just something where you'll want to talk to your client about, or maybe you have a particular form you're more comfortable with, and in those transactions, it'll be between you and your client to discuss. But there's a new form 800G. 800G was retired 2 years ago when there's a big revision to the new construction contract, Form 800T. 800G has been brought back. It's brand new. And the focus this time is on, all right, let's look at all the new construction forms and how do we decide, what to use when. You can see there's a chart here and then also an explanation of exactly what I'm talking about. So when you're trying to make that decision on when to use which form, then this is another resource to help you decide that and help you navigate between the two. And you can see this list right here. You can see a lot of differences between the two kinds of contracts. And you can take a look at those and figure out which one is more appropriate given your transaction. Back to the new construction addendum. So here's, as far as when to use the form, you got that paragraph there at the top. You've got some edits through here about warranties and things like that. Here's the biggest change, though, as far as what changes were made to help you bridge that gap between, this is basically dirt that we're going to build a house on, and here's a house that's, nearly complete, which is what this form used to be more geared for before. Now you have a section for additional improvements. You also have a beefed up paragraph B for changes and change orders. Otherwise, construction, A and C and cost of construction, those are substantially the same. But changes is really, and change orders here is a pretty big change there to help accommodate that. Here you've got also a timeline so that, when it comes to construction, putting some kind of constraints on what kind of builder delay there could be. And that was a big change that was done to the new construction contract 2 years ago. And, pretty good response on that so far. So, and that has been added here. And then here you've got some changes to inspections, and really the inspections are, pretty, similar to what they've always been. You have all the inspection rights that you would have under 2T when you attach this addendum. You also can do other things, and there's also a section for punch list items. But you can see here in general that the buyer may enter and inspect the property and the additional improvements at reasonable times and not interfere. And that's in addition to the inspections that you can do in 2T. All right. And that's why it says the property and the additional improvements. It's meant to encompass the access to property that would be in 2T, as well as the inspection items you would want to do pursuant to new construction and this addendum being attached to the contract. Here you get the installation paragraph cut down a little bit and the warning box moved out into the addendum. But those are the biggest changes for this. We've already kind of covered the new Form 800G that really talks about the differences between these two. Feel free to review this. One of the biggest things I would like to highlight, though, is, well, actually here you can see There's big differences between the pre-construction evaluation period and the due diligence period. So just understand the difference between those two. This paragraph does a pretty good job of that. That's an important paragraph here, I think. But at the bottom, you've got a pretty good explanation of warranties under North Carolina law as well as warranties in the contract. And I've gotten the question during a couple of these presentations of, which forms should we use? Because a lot of builder contracts will disclaim these warranties that are outlined here. These warranties are implied by law that I've highlighted right here. A lot of builder contracts will exclude these, and they can. They're allowed to, but they are not excluded in NC Realtors forms. So to me, it's something where if you're asking what contract should you use, it depends. Are you the listing agent or are you the buyer agent? If you're a buyer agent, then the more warranties your buyer can get, the better. And that means probably the NC Realtors forms would, if you can get the builder to sign them, would probably be a better deal. If you're a listing agent, then probably you're going to want to use custom forms from the builder where a lot of these warranties are excluded or modified in some way. It just depends what seat you're in. So just understand that and take a look at this guide when you have a chance. A lot of good information in here about new constructions. Here you can see the next form we got is new form 2A10-T, additional parcels. You can see at the top here, you can use multiple of this form. If you've got, 7 or 8 parcels or whatever, you can just keep attaching. These, exhibits are designed so that if you're a seller, you can just fill them out once and then you can attach them to 2T, 12T, 101, 103. You're going to attach them to agency agreements and to contracts, both. And basically, if you're doing that, you would have the seller sign down here, and then when a buyer comes along, then you could have them sign here. But really, truly, these are meant to be, something where if you fill them out once, you can, publish them with your listing, put them out there for the buyer, and then the buyer can use those things to be able to make the kind of, make their offer match. And trust me, you guys know this already, but I'll stress it again because when I get it as a hotline call, it's an unfortunate one. But every once in a while, I will get hotline calls where, like the parcels have not been correctly identified, and it's not a good call. That's definitely a call to your email. So make sure that you're using these carefully, but hopefully now you have an exhibit that actually goes along with that checkbox on the offer to purchase and the agency agreements. Moving on to the vacation rental addendum, you can see quite a bit of changes here on this form. And so if you've got a vacation rental, make sure you're still identifying the dates and times. That's really what this blank is for. Even though during the time period has been deleted, the goal was to try and make sure that you identified the reservations, all the reservations, including Airbnb and VRBO reservations on those lines. A lot of times, though, if it's a lot of reservations, you're going to do see attached and, just print out, something, these are the time periods where the vacation rental is already rented out. Here, you've also got a change where the seller will provide the buyer with copies of vacation rental agreements within 7 days of the effective date. It used to be 10 days within closing. So that's a pretty big change there. Make sure that you're paying attention to that. If the parties want to modify that timeline, they can by agreement, even if it's an informal agreement. They could do that, but just know that because this does not say 7 days of the effective date, time of the essence or something like that. So there is some wiggle room in there. Don't abuse it, of course, but at the same time, just understand that as far as when you're providing those things, that deadline has been flipped on its head to help the buyer be able to conduct due diligence a little bit better. And then in here, you've got basically a mini NDA, if you will, where the buyer agrees to keep that information confidential and not turn it over, and then to give it back or destroy it, as the case may be. Here you've got distribution of deposits and rents, and on here, if the parties, if there's some other way that they want to, prorate rents that have been paid, they can write it on the line here. And otherwise, it's going to be subject to that little proration paragraph in 2T. And usually it's done just on the date of settlement. Then, that'll be the point in time where it's cut off. Down here for the rental manager information, this blank has been deleted and a new blank in its place. And they're two pretty different blanks. Here, this was adopted. I want to, was it last year or the year before? But this blank here was adopted, right, to give a specific number that the buyer would have to pay if they're not going to use the seller's property manager. Okay. And a lot of times you have to understand, the buyer saying you're going to use the seller's property manager is a really big deal because depending on the answer to that, the seller may or may not owe their property manager, sometimes tens of thousands of dollars in fees that the property manager otherwise would have been entitled to, except for the seller selling the property. Okay. So this was a number that was to be negotiated between the parties where it's like, hey, I'm going to either will or will not use your property manager, but if I'm not going to, I'll pay you this much. And that number could be zero, or it could be whatever the seller's penalty is going to be if the same property manager is not used. Okay. Now the default is this. And instead of picking a specific number like the old blank, now it is just a maximum amount. And otherwise, the buyer agrees to cover all the costs incurred by the seller. So now let's say that the parties negotiate and they put in here a maximum amount of, say, if it's an expensive beach house, let's say it's like $40,000. Okay. Well, let's say they go through the transaction and it turns out, the buyer decides that they're not going to use the property manager, and then the actual fees incurred by the seller are only 20. Well, then in that case, the buyer would only be paying 20 instead of 40. If you put 40 in this blank, this is just an up to number. It is a ceiling. Otherwise, the seller can provide a cost sheet and just be like, here's all the costs I'm incurring because you're not using my property manager when you told me you would. Okay. Hopefully that makes sense, but if you use this section a lot, just understand that the default is that the buyer's going to cover all the costs incurred by the seller up to a certain amount, and then that way you don't have to keep recalculating if settlement gets delayed or something like that, which was the issue that brought about that change. Here you've got these bullet points that are really just moved up into the regular part of the form, so I'm not going to cover those, but those are the big changes with that addendum. Next up, we've got another brand new form. This is Form 2A15-T, and it's a judicial sale addendum. Historically, the NC Realtors purchase contracts don't work very well in the court context. They're really designed more for, a more conventional kind of transaction. However, this addendum makes a lot of adjustments to the purchase contracts to help them work in that context now much, much better. So let's take a look at this. I'm not going to cover it in too much detail. But here these general terms in paragraph 1, a lot of these are informational items. They may or may not apply depending on the transaction. But it makes it clear that the contract is going to be subject to any laws or local rules governing judicial sales. And a lot of times local rules vary a lot from county to county. And even within counties, there's different kinds of judicial sales. It's not always just a regular old foreclosure. It can be any number of things. It could be a partition action. It could be who knows what, okay? It could be a commissioner sale. So depending on what it is, a lot of things could change. But you can see here, there's a checkbox option for whether the due diligence fee will or will not be refundable. If the court does not give court confirmation, that actually varies county to county right now. But hopefully now it'll be something the parties can negotiate and make that more clear. Here you got the high bidder approval, an actual contingency built in, so that the contract is now contingent on the buyer, being the high bidder, and especially if there's an upset bid period. And then finally, Form 2T expects that there's going to be a general warranty deed, but in many, many, many judicial sales, you're going to get like I said, a commissioner's deed, a special warranty deed, who knows, a trustee's deed. It could be any number of things. So this here really modifies what the seller is delivering in the transaction and makes the contract accommodate that. So next, if you're doing a transaction in the court context, make sure you're attaching this addendum to the contract to help it work with the court process. Next up, we got Form 4-T, the agreement to amend the contract. And you got some changes in here. You got the warning box eliminated, but it's just moved down here. The biggest change here, well, probably two big changes. One, You can now add a seller, and you can add a buyer or seller, or remove a buyer or seller at the same time. There's now language in both of these paragraphs to help accommodate that. So, um, just know now that completes the circle. I think we started with, adding a buyer, and then we start with removal, and now you can add a seller. So now you can add or remove buyers and sellers with the agreement to amend. Here on the seller concession line, you've got percentages added here, so that's not just a monetary amount. So if you're using percentages, then now you can change that. And just some cleanup otherwise in this form. So those are the two biggest changes in the agreement to amend. And going back to the exclusive right to sell listing agreement, Form 101, let's go through the rest of the changes that were in this form. We already covered part of this, but you can see here at the top, for additional parcels, you get 2A10-T reference. That is the additional parcel exhibit. Most of you, if you don't already, now have the delayed marketing. NAR released that new rule last year on, they called it delayed marketing, but a lot of you are probably MLSs that call it limited distribution or exposure, one of those things. In any event, you can think about it as kind of a medium option for marketing the property between public marketing, and you can see down here, office exclusive, which is still there. And so now there's an option for that. If your MLS doesn't have it, then it's something where you would explain to the seller that this is not an option in our MLS. But honestly, you could probably make some changes to the public marketing option that would actually do something that's close, depending on how expansive your limited distribution is. Because you can see here, if you do have it, then you know that there's a lot of options for how the seller can market the property, even though within the MLS, there's going to be, the property is just going to be marketed to the clients of the firm and the brokers who participate in the listing service, right? So it's not worldwide, full distribution marketing, but you can also, add additional things down here if you wanted, if you had specific places you wanted to market in addition to, just the participants in the MLS and the clients of the firm. So if you don't have it yet, then my guess is you probably, may have it soon. And if you don't, then that's okay. That's something MLSs, they can decide whether they're going to approach that or not. So now that has been added to the form in any event, probably applicable to your MLS, depending on where you're at. If it's not, just explain to your seller it's not applicable. However, one thing that was part of that new rule that came out last year was these disclosures that are required to be right here, and those have been added so that you can look at those disclaimers. Basically, it's informing the seller, hey, you are not, if you're using the limited distribution or exposure or office exclusive, you are not getting the widest publication. That is going to have consequences. It may have consequences to the ultimate price of the property. So make sure that you are covering that with your seller, explaining what the potential upsides and downsides. Because at the end of the day, it's really about the seller choice. And sellers who have gone through the process before, they know that there are certain consequences to public marketing. For example, you do public marketing, yeah, you might have some investor types who are rolling up to the property and knocking on the door. That happens. I get complaints about it constantly. So some sellers may want to limit their distribution just to real estate agents, because real estate agents, and in particular you guys realtors, are way less likely to do that. So it's one of those things where, and notice I said less likely. And I mean less likely. I mean a lot less likely, but every once in a while, it's just one of those things. Be courteous when you're out there. That's all I'm saying. Sometimes I get the hotline calls when somebody feels like somebody's not being courteous, and I always like to encourage you all, be courteous. In any event, I will get off my soapbox on that one. But this disclosure and this disclaimer here, I guess you could say, is about if you're going to do office exclusive, or if you're going to do limited distribution, then make sure you understand the impacts to the seller. And like I said, both the pros and the cons on that. We've already covered this section. If there's questions about that in the chat, I'll get to those in a minute. And then down here, you have seller. This will be in red in the final form as well. Seller has to provide a valid ID. Is that going to help you avoid all scammers? I don't know about that, but at least it's something. And it's something where, to the extent possible, I can tell you NC Realtors is fully dedicated to make sure you guys have as many tools as possible to avoid scams. Also check with your local board. A lot of local boards are doing some really good work on giving you guys additional apps and options to be able to not just discover scams, but share information if you run into one. So make sure you're plugged into your local boards about those benefits. Here you can see more on FinCEN. If it comes up again, there's something, a resource there in the listing agreement. You can cover the seller. Until then, until it pops back up, I think it's something that you can tell most sellers, it's not applicable right now. Here you've got the vacant land disclosure statement. This is Form 142. It is a required form when you do a contract with the vacant land contract, Form 12-D, okay? It is not required otherwise, but it is something where if you have vacant land, it's a good idea to be able to discover and disclose material facts about a vacant piece of property. In the past, you can see in the old version down here, there was quite a few check boxes and blanks. The feedback from that was a lot of sellers were hesitant to fill it out because of that. So you can see here now with this rewrite, instead, you got one question, yes, no, no representation on a whole list of things. And then if yes, please describe. So hopefully that makes this form, it's still really designed to cover the same topics and to help you discover and disclose same things. Obviously, the seller can still do no representation if they wish. But if they do, at least have the discussion with them, push them on it, make sure you're doing something to try and discover material facts as they may come up, okay? In any event, hopefully the form will accomplish the same goals as far as disclosure of material facts, but also be a little bit easier for a seller to fill out, hopefully entice them to fill it out a little bit more than, something like this, okay? Moving on to the exclusive buyer agency agreement, Form 201. You can see here a little language added to, affirmatively require the buyer to comply with closing attorney instructions and any purchase contract, and this agency agreement would be implied, but that's certainly in there. Language here to make it a little bit more clear about when they need to provide you with stuff they've signed with another buyer agent. Make sure you pursue that. If they even mention that they've talked to another agent, I always encourage people reach out to that other agent, even if the buyer says, I didn't sign anything. Okay, well, a quick phone call, a lot of times you will discover that is not the case. So make sure you're doing that and make sure you're following up on that. If the buyer tells you something, follow up on it and make sure that they are not having, the same kind of memory that my teenagers have in my house, if that makes sense. Anywho, fee for services, you got a fee now for new construction. Make sure the buyer fills this out, even if they swear up and down they're only shopping for older homes, they're not going to buy a new home, blah, 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 blah. No, fill this out because that if every time a buyer who swears they might get into an older home, you show them one newer home because that's what's in their price range and it actually makes more sense and it's a better location, everything else, they walk in. You know how it is. You know how it is. And in the old versions of the form, because it wasn't covered specifically, so every once in a while there'd be a question of, all right, well, if there's a closing on the vacant land, then do you get paid on the new construction when that's done, when the CO's done? How do you calculate the fee? And to me, the best reading of the buyer agency agreement was always that, yes, you would get paid on the whole thing. But every once in a while, there'd be buyers who would try and, split hairs and make an argument the other way. This closes that gap, okay? That's what this is about. But you got to fill out the percentage there for new construction, what you expect to be paid. Even if, you expect to sign some kind of agreement with the builder, okay? Make sure that your buyer agency agreement covers you. All right. Moving on down, another FinCEN paragraph there for you to discuss with the buyer. Moving on to the referral agreement. Form 730. Uh, in the past, I would get hotline calls from time to time, and it would almost, in this particular scenario, it would be, either the firm or an agent who had left the firm asking who owns the referral agreement. Like, I left the firm, the firm is saying it's theirs, but that was my, cousin or whatever, and so that was mine. It should be mine, etc. Okay, and it's interesting because I just wrote an Insight article that will be coming out soon that kind of talks about this a little bit. But in the past, the this question of who owns the referral, that would be decided by the firm's policy and procedure manual. It could be decided by your independent contractor agreement, or just if neither of those things were there, then like the customary practice of the firm, right? And maybe even an oral agreement between the agent and the firm. Okay. Well, now, instead of relying on those things, and, firms, depending on, how big or small they are, they may or may not have something that addresses this situation. Now in the form, it is addressed directly, and the default is the firm. Now, if you want something else, that's fine. You can put it on information notes. You can put it down here in the other checkbox. You can do whatever you like. But just know in red here, the default is the firm. And if it's something else, then make sure that you do that. And now also, depending on the circumstance, some firms, they want the managing agent or BIC signature. So that's on here as well. Okay. So just be aware of that. That's an important one for a lot of you, especially, when you're, maybe if you're contemplating transition to a firm, then you want to make sure that's something that is clear. Here you got Form 760, the professional service disclosure and election. You can see there's no yellow on here because it's been completely rewritten. Some of you, if you're using this already, the lines here between selected and waived for the initials is a little narrow, and we got a little bit of feedback on that. So I may be doing some edits to this to send out to the vendors so that the initials fit in there better. But for right now, you can see, this document has been expanded greatly. And the reason for that is because this document is extremely important. If you're not filling this out, you should be doing it every transaction. You can see here, you get check boxes for buyer and seller. So if you're a dual agency, you can do it for each of your clients, or just, indicate which one. But it's been expanded tremendously to include a lot of specific things. And that's because, depending on this in the situation, I, one of the things that I've done for years is licensed defense at the commission, as well as, handling lawsuits and things like that that you guys face sometimes. These forms, when they're filled out correctly, are so valuable when it comes to talking to the commission about a case, about whether something was elected or whether it was waived. Same thing when it comes to legal claims. This is a form that, if you're not using it, again, you should strongly consider it. The interesting thing is, when this form was being revised, it was very, very interesting to listen to all the different ways this form is used. Some people use it as a checklist throughout the transaction. Some people do it at the beginning. Some people do it at the end, right before closing. And there might be pros and cons to when you fill this out or how, as far as a timeline. However you do it, this form and the rewrite should accommodate however you've done it. So just know that it's something that the rewrite wasn't meant to change when or how you fill out the form. It was more about, let's get more specific. Let's talk about all the closing services. Let's talk about all the different insurance services. Let's talk about all the different kinds of inspections instead of just a few. So you can see now you've got like almost an entire page just on inspections. So you still down here have the disclaimer, hold harmless, and things like that. That all is relatively the same. But here you also have additional services. So however you fill this out, you can continue to do so. But just be aware of that. And then finally, the last form I've got for you today is actually a property management form. It's just a simple flow chart on how summary ejectment cases work. And on the second page, it's got some important information to talk about that. If you've got, a seller or a transaction, or if you're a buyer, if you've got a buyer who's looking to buy a property, just the biggest thing I will say about this, if you're the listing agent in particular, don't make promises you can't keep. Okay. Evictions can be lengthy. Depending on the county you're in, they could be very lengthy. So I would just say this gives a general overview. And if you're, unless you're experienced with evictions and property management, also who happens to buy and sell, then it's probably something where you want to get an attorney involved and have them take a look at that. So I want to make people aware of it though, because honestly, this flow chart was really, I encouraged property management division to adopt it. One for landlords, sure. But number two, I was just getting way too many hotline calls from agents, from you guys, from members who owned property. You have your own rental properties, but you've never had a problem with the tenant before. Is there a resource to, give me sort of a 1,000-foot view of how I deal with a tenant that, is not cooperating and I need to evict. So that's really where this came from. So hopefully you guys find that useful. There's actually quite a few forms that property management has been putting out last couple of years. If you haven't looked through those, I'll just mention one is there's a personal property flow chart to figure out how to deal with a tenant's personal property once they leave. So there's another flow chart on that. And then there's also an ordinary wear and tear chart to try and figure out, all right, so the tenant's out. How do I decide what's ordinary wear and tear or not? And there's not like a specific law on that. Well, hold on. There's a law. It just doesn't say exactly what is ordinary wear and tear or not. It just says you cannot charge the tenant for ordinary wear and tear. So how do you determine that? It's a guide that kind of gives you sort of a thumbnail sketch of what is or is not. And there's actually a list in there of this is, this isn't, this is, this isn't. And it's not law necessarily, but it's just something to help the parties get on the same page about it. All right, I'm going to go ahead and look at the questions. See if we've got questions in here. All right. So first question is, the new buyer agent compensation addendum, is there a guideline who should be filling this out? So it's always been the case of 220, either side could fill it out. So I think that's still the case. Because it's an addendum to the contract, I think probably more times it will come from the buyer now. But it doesn't have to be the case. It could be something where it could still be filled out and sent by either side. Either way, it is fine. Yes. There's something that I forgot to cover, and let me do it here for this question. At the top of this form, it says only use this form when the seller is providing a credit to buyer. The credit mentioned in there is just the credit in the form. So that's it. Like it's just if you're doing, credit, then it's just the credit that's in the buyer agent compensation addendum. If you're doing a different credit for, new blinds or something like that, that would go on the seller concession page on the contract. But the credit that's mentioned here is just the credit for buyer agent compensation. Okay. If there's a change to 220, um, right now there's not a form like there's not a 4T or something like that to change it. You can make changes on the form itself. You can um, uh, you could submit a different one and have the parties sign it. The parties, signatures and dates are down here at the bottom. So I guess you could do that. I'm not sure how lenders are really what lenders are going to feel the best way to do a change to 220 is. Whatever they say, I would go with that. So however you want to do that is fine. Let's see. There's a question here of, if you don't identify Form 220 in the offer to purchase. So the offer to purchase is here. So if you don't identify it here, is it part of the contract? If you attach it to the contract, even if it's not identified here and all the parties sign it, I think it's pretty hard to argue that it's not part of the contract. Could a party potentially make that argument? I guess. But you can see here on Form 220, like other addenda, both the buyer and seller sign, and it's going to be dated. So especially, if you have that information from, whoever your online signatory vendor is, they'll be able to tell you how the party signed. If the party signed it, then the law would presume, even if this is not done right, if the parties signed everything, I think the presumption would be it'd be pretty hard to get out of it. All right. So the question here, can the parties make a separate arrangement on delivering the money? Yeah, you guys do that every day, all day. Just be aware, waiver is a real thing in the contract. And what that means is that, if you on behalf of your client say, yeah, you can, like, you don't have to give us the due diligence fee on Wednesday. You can just give it to us on Friday. Okay. You better make sure your client's okay with that. Okay. Because that is going to be what is in the law called a waiver. A waiver is a real thing. You can waive your rights under a contract. Now, technically speaking, you've got to have a writing to amend a contract, right? But if you later, don't like what's going on Thursday and then want to go back on giving them until Friday to pay, you've got a difficult situation because you've already made a waiver to make the payment due on Friday, even though it wasn't a technical, amendment to the contract, right? That's signed by all parties. That's a suggestion, so I'm gonna move beyond that right now. There's no grace period for the settlement date. The grace period is just well, no, there's a grace period for the settlement date. Grace period for the settlement date has not moved. So that is still here in paragraph. You can see it on your screen, paragraph 12. So that has not changed. The grace period I'm talking about is the new one for the due diligence fee being paid, which is the next banking day after the effective date. Let's see, judicial sale addendum. Yeah, I don't know. The judicial sale addendum, I think the seller could complete it or the buyer could, either one. It would be part of the negotiation of the parties. It doesn't have to be either way. Like it doesn't have to be one party or the other, just like any other, addenda to the contract. What if a seller demands hold on, I can't make that. There we go. Well, if a seller demands one banking day delivered daily but refuses to provide wiring instructions, I mean, it's the buyer's duty to pay. So, up here on the first page of the contract, if the due diligence fee is, say you've only put wire transfer, that's not usually the case, but let's say you only have wire transfer and then the seller doesn't provide that, and then they make a demand. Yeah, I guess the buyer will be in a position to make a couple different legal arguments, including the argument of impossibility. Would that be successful? I don't know, but in any event, I would try to work that one out. But if you've got cash, personal check, official bank check, wire transfer, electronic transfer as all as options, then the seller refusing to provide a wire wouldn't be an issue because they've already agreed to accept it in a bunch of different ways. The buyer can pay any one of the ways that are checked there. So the seller and the buyer need to make sure they negotiate that at the beginning as far as how payment is to be made. All right. No more questions, and that's fine. If you think of one, in the next 30 seconds after we hang up here, no problem. We've got the legal hotline available for you. And that's, you can call the office in Greensboro or you can email legalhotline@ncrealtors.org. Otherwise, I appreciate you guys giving the opportunity to get on here and talk about the forms changes. And I hope you have an excellent rest of your day.